If you're here, that means you probably have some questions about transfer on death deeds and trusts, and which one might be the best choice for you and your family. Hi, I'm Chuck Roulette. I'm an estate and elder law planning attorney licensed to practice in both Florida and Minnesota. And in today's video, I'm going to compare transfer on death deeds to trusts to help you decide which may be the best fit for you. Now, at the end of the day, both can help you pass on your property, but they're not created equal. Before we begin, if you haven't already, make sure you hit the like and subscribe button so you'll be notified when I post new videos like this one. And if you have a question, post it in the comments below and I may answer it in an upcoming video. Finally, if you stay until the end, I'll share some additional resources where you can learn more. So on the surface, a transfer on death deed might seem like an easy way to transfer property to your loved ones after you pass away without the hassle of probate. But as convenient as that sounds, there are some serious risks you need to be aware of. So in this video, I'm going to compare TODs and trusts and explain why a trust may be a better option for your estate plan. So let's dive into the differences, starting with what exactly a transfer on death deed is. A TOD allows you to name one or more beneficiaries who will inherit your property when you die. No need for probate. When you pass, the property automatically transfers to them. But while a TOD may sound like an easy fix, it's important to know that they come with limitations and sometimes hidden dangers. I did another video on the hidden dangers of transfer on death deeds, and I'll actually post a link to it below. Now let's compare that to a trust. A trust is a legal arrangement where a trustee manages assets, like your home or investments, on behalf of your beneficiaries. Trusts come in two main types: revocable living trusts and irrevocable trusts. A revocable living trust lets you stay in control of your assets during your lifetime, and you can change it whenever you need to. An irrevocable trust is more permanent, but it offers powerful protection against creditors, lawsuits, and even long-term care costs. If you would like to learn more about the differences, I'll post a link to a video I did on the differences between revocable and irrevocable trusts as well. So the first way to distinguish perhaps a TOD from a trust is their availability. Transfer and death deeds are not available in all states. Trusts, on the other hand, are recognized in all states. So this can be of particular concern for people that may own property in a state that allows TODs and property in another state that doesn't. A second big difference is flexibility and control. One big difference between TODs and trusts is just that, flexibility and control. With a TOD, once you name your beneficiaries, that's it. The property passes to them when you die, and you have limited control over what happens after that. For example, if you name multiple beneficiaries, they'll each own a share of the property after you pass. If they can't agree on what to do with it, like whether to sell or keep the property, it can lead to disputes and even legal battles. To complicate things even more, depending on the law of your state, your children's spouses will also likely receive an ownership share. Yes, you heard that correctly. In many states, spouses automatically have an ownership interest in any property or any other real estate that their spouse owns, even if they're not named on the deed. So that means your kids' spouses will also likely have to sign off on any sale or agree to what happens with the property. In fact, several years ago, a family contacted my office after the passing of their mom. She had worked with another law firm to prepare a TOD transferring property to the kids. However, one of their sibling spouses was now demanding the property be sold to her son for less than fair market value and was refusing to sign off on any other sale unless the family agreed to her terms. Well, the family ended up needing to go to court to resolve their issues. With a trust, on the other hand, you can set specific rules on how your beneficiaries will receive the property, when they get it, and under what condition. Again, if your heirs are young or financially inexperienced, this can be a huge benefit. Also, only the successor trustee of your trust will be required to sign off on any sale, not all of your children and their spouses, so it's less likely to result in family disputes. Another difference is avoiding probate and privacy. Now, both TODs and trusts are designed to help you avoid probate, but here's the catch. A TOD only avoids probate for real estate, your house or other property. Any other assets like bank accounts or personal belongings may still have to go through probate. With a trust, you can place almost all of your assets in the trust, your house, your investments, even your personal property. That way, your entire estate avoids probate, not just the real estate. And here's another big plus: privacy. Probate is a public process, which means anyone can see who your heirs are and what they inherit. Trusts, on the other hand, keep everything private, ensuring that your personal financial matters stay out of the public eye. Another big difference is protection from creditors and divorce. One of the most significant drawbacks of using a TOD is the lack of protection it provides to your family. A TOD doesn't protect your property from creditors or lawsuits. Once your beneficiary inherits the property, it becomes part of their estate, which means it's open to claims from creditors or can even be divided in the event of a divorce. Now let's compare that to a trust. With the right provisions in your trust, you can protect your home and all of the other assets you leave for your family in the event they get divorced or get sued, or even from bankruptcy due to a job loss or medical emergency. So how would you feel if you found out that your son or daughter lost their share of your home and life savings in a divorce? Well, with a properly prepared trust, you can protect it. Another big difference is protection from nursing home and long-term care costs. If you need long-term care or go into a nursing home and Medicaid is involved, your home could be at risk with a TOD. Medicaid can place a lien on your property to recover those costs. However, again, with the proper trust, your property could be protected from these claims. In fact, if you would like to learn more about how you can protect your home and life savings from long-term care and nursing home costs, I've written a book, Save Our Home: How to Protect Your Home and Savings from Long-Term Care and Nursing Home Costs. And I've provided a link in the description below where you can download your copy. I'm also going to be hosting an online class where I reveal strategies I use with my private clients and their families for how they can protect their home and savings from long-term care and nursing home costs. Again, there's a link in the description below where you can sign up and join us. Another difference between TODs and trusts is insurance coverage. So here's another hidden danger of TODs: insurance. In the case of Strope Robinson versus State Farm, the Federal Appeals Court in the Eighth Circuit ruled that homeowners insurance doesn't automatically cover beneficiaries inheriting property through a TOD. So if something happens to the house, like a fire after you pass, your heirs might be left without insurance protection. Now, the case arose in Minnesota, and the state passed a law later on to extend coverage for 30 days after your passing. However, it's only for 30 days, requires notice to the insurance company, may still be an issue in other states outside of Minnesota, and still doesn't solve the other issues with TODs. With a trust, the property is owned by the trust, so insurance coverage can be maintained without a gap, ensuring your heirs are fully protected. Another difference is handling multiple beneficiaries and avoiding conflict. So if you name multiple beneficiaries on a TOD, they could end up fighting over what to do with the property, just as in the example I noted earlier. One might want to sell, while another might want to keep it. This can create conflict that could lead to court. With a trust, you can avoid these issues by appointing a trustee who makes the decisions based on your wishes, avoiding disputes and keeping things running smoothly. So while a transfer on death deed might seem like a simple solution, a trust simply offers much more flexibility, protection, and peace of mind. It can help you avoid probate, protect your assets from creditors, and ensure your wishes are carried out exactly as you intend. If you want to learn more or you'd like to schedule a consultation to discuss your planning goals and how we can work with you to create a custom tailored plan to achieve them, you can visit our website at roulettelaw.com. I'm also hosting another free online masterclass where I reveal strategies to help you avoid probate. I'll discuss wills versus trusts, how to save on taxes, how to protect the money you leave for your kids in the event they get divorced, and much more. And again, I'll provide a link in the description below where you can sign up and join us for that. I hope you found this video helpful, and I look forward to seeing you in either an upcoming video or one of the masterclasses. Be well.